Good evening, everybody. Good evening. Welcome, everybody, to the Andrew Breitbart Freedom Center here at the Heartland Institute. Great to see a good crowd out tonight despite some earlier threats of some bad weather. So this is great to see all of you here tonight for our event on constitutional soundbites with David Shestokas. I'm Kyle Michaely, and I am the project manager of constitutional reform here at the Heartland Institute. Heartland is a 32-year-old think tank. Up until about 10 months ago, was based in downtown Chicago in the heart of the financial district. Our mission since our founding in 1984 has been to discover, develop, and promote free market solutions to social and economic problems, to fight for policies that shrink the scope and power of government, to increase individual liberty, and to encourage prosperity through free markets. Heartland covers key aspects of domestic policy through our 5 policy centers. Those include the Center on Budgets and Taxes, the Center on Education Transformation, our very own Consumers for Healthcare Choices, the Center for Climate and Environmental Policy, and our newest center, the Center for Constitutional Reform, in which tonight's event falls under. We're amazingly effective in our mission. Just ask one of our opponents in the arena of ideas. Google us if you want to. Just don't believe 97% of what they're saying. As they say, if you're not catching flack, you're not over the target. If you like what you see tonight, whether here in person or watching online through our live stream camera, which is straight ahead of me, I encourage you to look around heartland.org. Check out our blog, Somewhat Reasonable. Check out our daily podcasts on iTunes. Check out our YouTube page, which contains the live stream tonight's event and also to our past events. You'll see more that is to your liking. Talk to a Heartland staffer about how you can browse around our beautiful Michael Perry Mazur Library. It has one of the largest collections of economic books and free market thought anywhere in the entire Midwest. What is without a doubt one of the best. It grows each day, and we welcome your donations to make sure that we continue to grow the library. We're in the beginning of summer as we're about to hit summer solstice, so if you have any relatives in college that are in need of an internship and would like to be immersed in a free market think tank, contact us because we have plenty of opportunities available and much to share. If these things are important to you, we would love to have your support so we can keep informing the public and elected officials about the benefits of free markets and the importance of protecting our liberty, our free choices in all areas of public policy and life. Now we're here tonight to talk about David Shestokas' book, Constitutional Soundbites, and how it really promotes and portrays our nation's founding documents in more of a 21st century type of format as now everything is going digital. Our speaker, David Shestokas, earned his Bachelor of Arts degree in Political Science from Bradley University in Peoria, Illinois. He earned his Juris Doctorate degree from the John Marshall Law School in Chicago, where he graduated cum laude, where he also served on the John Marshall Law Review. He also studied law at Trinity College in Dublin, Ireland. He is currently admitted to practice law before the Illinois State Supreme Court, the United States District Court for the Northern District of Illinois, and also the Supreme Court of the State of Florida and the United States District Court for the Middle District of Florida. Shestokas founded the law office of David Shestokas and has been practicing law for over 30 years in various disciplines, from criminal defense to corporate litigation. He has also served as Assistant State's Attorney for the Cook County State's Attorney's Office, where he has been involved in over 10,000 criminal prosecutions. Also, he worked on the Felony Review Unit and also participated in over 400 police investigations. Shestokas is the previous host of the radio program Constitutionally Speaking and has worked closely with Dr. Berta Artis to produce a Spanish language version of the book Constitutional Soundbites to serve the ever-growing Latino population which we see in Illinois and nationwide. Without further ado, it is my pleasure to introduce to all of you David Shestokas. Thanks.
Thank you so much, Kyle. It's wonderful to be here, and just really quick, I know it's difficult, but it's Shestokas. In any event, I am really glad to be here. I first actually came to know Joe Bast and Heartland Institute in 1990 when I was a candidate for the United States Congress as a Republican nominee running against a fellow by the name of Bill Lipinski. It was considered to be somewhat of a suicide mission, and I did get about 38% of the vote, but there was two places I actually got some help, despite the fact that people considered it to be suicide. Certainly on policy issues and education about the important things that I was interested in at the time when I was running for Congress, I got from Joe Bast and Heartland Institute in 1990. And I actually, the other place I got some help at a time when nobody was really helping me when I was running for Congress was Newt Gingrich. Mr. Gingrich and Mr. Bass were very, very instrumental in helping me develop things when I was running for the United States Congress, and I think influential on how I move forward in my thinking on many, many subjects. Kyle, as you know, he mentioned that he's in charge of the Center for Constitutional Reform. They provide an invaluable resource here for gathering information about the progress of the Article 5 movement to amend the Constitution through a special part of the Constitution regarding the Convention of States. It's something that's never been used before. There's a lot of activity in that regard, and a great clearinghouse for information on that situation is Kyle and the Center for Constitutional Reform here. I get regular updates on what's going on, and they have a lot of participants from around the country. And I think if you're interested in seeing what kind of reform of the Constitution could be done outside the United States Congress, you should follow the work that Kyle's doing. Now, we're here to talk about my book, Constitutional Soundbites, and in a little bit regards its Spanish companion, Cápsulas Informativas Constitucionales. But those aren't about reform, they're about understanding. And while it's likely, probably, as I look around and here in Heartland, and there's, I suspect, some of the people that are tuned in online, there's probably a number of them that, in fact, have read the Federalist Papers. I think we can say with some safety that's not a common situation these days. In the 18th century, long format newspaper essays were the common way for people to communicate. But if Americans these days develop any kind of common understanding of anything, it's usually through something like tweets and blog posts and very short bits of information. Constitutional Soundbites was designed with that kind of idea in mind. It's a tool for both those wishing to learn more about the Constitution and, in fact, for those wishing to perhaps explain and teach to others about the Constitution, because we wanted to put together and revive the common knowledge that Americans should have to have the heritage that comes from the founding documents, heritage which to the founders was really just common sense. 6 years ago, I was part of a bar association group that took time and spent time at the Constitution Day at area high schools. And I started the presentation in sort of a Socratic method, and I asked the kids, sophomores in high school in an American history class, what year was the country founded? I figured that'd be something easy to start with, and the first answer I got was 1700. And the next answer I got was 1800. And I said, no, it's before that, and it's after that. Eventually, we zeroed in on 1776, and I thought I'd have another easy one. I said, okay, what day is it? And we drew sort of a blank. And eventually I said, okay, hot dogs, hamburgers, barbecue, fireworks. And everybody, oh, somebody shouted the 4th of July. I did 4 or 5 other classes that day. And as I went home that evening, I thought, geez, it seems to me that if I can try and do something about this I'm going to try and do something about that. And eventually that led to a 3-year stint on the radio with Constitutionally Speaking. And we talked about the Constitution and did a weekly show for 2.5 hours. And during the week, prior to the shows, we would have promotions for the show. The show would be, the promotions would be something like, oh, what did Jefferson mean by all men are created equal? Or what can a president legally do with his pen and his phone? And then I'd answer in 60 seconds. And the 60-second answers, I started to collect them. And then I collected them, and then I added to them. And eventually we got 150 of them. And the 150 questions and answers became constitutional sound bites. So it was built around the method by which people communicate today in short question and answer formats. And so that's what we tried to do, is to try and communicate for people in a fashion that they understand today. Beyond the unique style, constitutional sound bites, to my knowledge at any rate, is the only work that really relates the Declaration of Independence, the Constitution, and the Bill of Rights together. There's 50 books in the bibliography of constitutional sound bites. I've read them all, and I've read more, and as far as I can tell, there's nothing. Some places they teach about the Constitution, some places they teach about the Bill of Rights, some places they teach about the Declaration of Independence. I've yet to find anything beyond this book that relates the three of them together. It provides a grounding in America's first principles for the modern mind. The book's style is more akin to tweets and blog posts and compatible with the 21st century attention span. And again, for audiences like this one, I'm sure, who are largely well-grounded in American first principles, it may very well provide a tool to communicate with folks that aren't as well-grounded as yourselves. And I would encourage you to take a look at it for that type of situation. At any rate, Constitutional Soundbites is my contribution to trying to communicate, as Thomas Jefferson said his goal with the Declaration of Independence was simply to explain the common sense of the subject. Because, in fact, most of this is just common sense. The Constitutional Soundbites comes, as we said, in a quick question and answer format. We have another project that we're working on that's grown out of this at the moment, and that's developing a curriculum for charter schools that's built upon the information and the format of the book. We're very excited about that. But the book makes less complex, which was really not that complicated 240 years ago. In fact, the matters weren't really that complex. As I think back to law school, I think about the fact that really what we taught then, or what I was taught then, was constitutional law, and hardly anybody spent any time with the Constitution. And constitutional law and the Constitution are not the same thing. Our lack of common understanding demonstrated clearly a couple of weeks ago in Louisiana. Louisiana, there was a bill pending before the House of Representatives to require recitation and study of the Declaration of Independence in the middle schools of the state. A state representative by the name of Barbara Norton actually got up in opposition to the proposal to teach the Declaration of Independence. What she said was, "One thing I do know, all men are not created equal. When I think back in 1776, July the 4th, African Americans were slaves, and for you to bring a bill to request that our children will recite the Declaration, I think is a little bit unfair for us to ask these children to recite something that's not the truth." Representative Norton and so many Americans have missed that America is in fact the only nation that was ever founded on timeless truths and universal ideas. They're set forth in the Declaration of Independence, and one of the things we work to do in constitutional soundbites is to show the relationship between what's in the Declaration of Independence and the execution in the Constitution. Constitutional soundbites actually contains 140 references to the Declaration of Independence and how aspects of the Constitution are meant to execute the principles of the Declaration. For whatever it's worth, though I haven't heard from her, a couple weeks ago I did send Representative Norton a copy of the book. We'll see if we do hear from her. I did send a copy of the book to somebody else this past week, however. And on the bright side, in South Carolina, just the last couple of weeks ago, they passed a law that Governor Haley signed into law. And it's got a great name. They require study, and it's called the South Carolina Founding Principles Act. Now, Illinois last year passed something called civics education, or requiring civics education, which was something new for Illinois, or new in recent days. But South Carolina, as far as I know, is the first state that, in fact, is requiring study of the founding principles, which is completely different than civics. Civics can be sort of like, for those of us, some folks here look to be my age, and some of us probably grew up with Schoolhouse Rock. And that's kind of a form of how a bill becomes a law. That's kind of a form of civics, but that's not really what this is about. You know, Constitutional Soundbites has some philosophy. It's got some history, and there's technical details about how the government runs. But I'm going to share with you today some of the thoughts and stories that guided me when I chose the different selections and entries to go into the book. And I hear so often these days, many political leaders, when they disagree with somebody and they try to diminish their opinion, they go, "It's not who we are as a people." You know, we hear that phrase so often, and from everybody when they just want to make a point about disagreeing with folks. But, you know, if you think about it, I speak pretty good English. And if I lived in London for 20 years and I pledged allegiance to the Queen, would I ever be British? No, I'd never be British. But by understanding, subscribing to, and adopting the principles, the first principles of America that you find in the Declaration of Independence executed in the Constitution, it's the only country in the world where you actually can become an American. And the principles in those documents are who we are supposed to be as a people. It's our common heritage. Constitutional Soundbites, the way I put it together, it's not liberal, it's not conservative, it's not Democrat or Republican, it's American. And that's what we're trying to teach there. We focus on that point. And we focus on that point because there was so much common understanding among the founding generation, and if we could revive that common understanding, I think there's a good chance that the people that try and slice and dice us and play identity politics would have a much greater problem in doing so. And one of the ways to do that is to understand and share our first principles. Now, the Declaration and Constitution are certainly well revered for their eloquence and their grand aspirational philosophies and their technical details to execute some ideas of some great philosophers like Montesquieu and Locke. But in the end, what they really are is a couple legal documents. Declaration of Independence declared our separation from England, and the Constitution organized the government. When the Declaration of Independence was signed, 25 of the 56 people that signed it were attorneys. Attorneys were lawyers. Yeah, they were lawyers, and 22 of the 40 signers of the Constitution were lawyers too. But of the folks in both those groups that were not lawyers, the rest were business people and active in public affairs. And so there was a commonality, there was an understanding among the people that structured these things that is important for us to understand. Very often we talk about terms like limited government and enumerated powers. Those terms are not in the Constitution. They're not in the Declaration of Independence. There's some oblique references to the same kind of thing in the Federalist Papers. So where do those come from? They come from the commonality of understanding. They don't come from just the words. They come from the structures of the documents. And that structure can largely be attributed to two of the 47 lawyers that were involved in this project. Two of them were instrumental in this situation. And of course, the first is very well known, Thomas Jefferson. He was admitted to practice law when he was 24 and wrote the Constitution when he was still a young 33. The other guy isn't so well known, though the fact is he's the author of perhaps the most famous phrase in American history, Gouverneur Morris. Morris graduated King's College, which is now Columbia University, when he was 16. He was admitted to practice law when he was 19. He wrote the Constitution, and we'll talk about that in a bit. But he wrote the Constitution when he was 35. You know, when I consider those two guys, I feel like a bit of an underachiever. I was admitted to practice law at 35. I was way behind those two fellas. On the bright side, before I was a lawyer, for most of my life, I sold beer. Actually, I delivered my first case of beer when I was 5 years old. It's true. I delivered my first case of beer when I was 5 years old, and I learned to drive a beer truck before I learned to drive a car. So I felt a different kind of kinship, although that may be why I tried to keep things simple in constitutional soundbites, because at heart I'm still sort of a beer guy. You know, at heart I'm still sort of a beer guy. I like to think I'm more of a beer guy than a lawyer. And I did feel a different kind of kinship. Yeah, beer guy at age 5. So for 30 years, I wasn't a lawyer until I was 35. So the fact is I've still been a beer guy longer than I was a lawyer. At any rate, one of the reasons I feel a different kind of kinship is, of course, a lot of the business of both the Second Continental Congress that issued the Declaration of Independence and the Constitutional Convention that put together the Constitution took place in a place in Philadelphia called the City Tavern. And a while back, not that long ago, I was lucky enough to be in the City Tavern, which is still there 240 some odd years later. And I had a Jefferson's Tavern Ale, brewed to Thomas's recipe. And I felt like this was a kind of a kinship, and I envisioned the role that beer played in the founding documents. So it made me feel closer. I was still a beer guy. But quiz games and contests, something that always are popular in taverns. And so we're going to do a little one now. And I believe everybody has little papers on their table. Pardon me? You could write on my bio, but there's actually little sticky notes. And there's pens on the table, everyone. And there's no using of your smartphones or doing any kind of research in answering this question. And I do have a prize for the first one of these answers that I get right. And we'll ask it. We'll do this. We'll get the answers later. But right now, we're going to ask you to name the 5 rights that are in the First Amendment. For those of you at home, at Shestokas on Twitter, and you can tweet me that, and I'll share a tweet with my 98,000 followers for you. So we'll collect those in a while. You don't have to come up with it right away, but I want you to write down what are the 5 rights in the First Amendment. There's 5 rights in the First Amendment. A recurring theme in Constitutional Soundbites, I'm going to go back to the book, a recurring theme in Constitutional Soundbites that I think is untaught is the worldwide impact of these documents. You know, the proposal and ratification process of the Constitution is likely the singular most important secular event in human history. The world changed on September 17th, 1787. Before that date, there were no self-governing people in the world. September 16th, 1787, the world was dominated by kings and czars and chieftains and sultans and despots, generally speaking. And as it had been throughout human history, before 1787, self-government had existed for very short periods in very small places and a long time ago. Perhaps in some small Greek city-states and a little bit of time in the Roman Republic. But for the most part, self-government had not been something that was known in human history. The promise of the Declaration of Independence actually started to be fulfilled when the Constitution was submitted for ratification. The period of 1787, 1788, during the ratification process, debates in the newspapers, in the taverns, in the churches, in the farms, free speech that's when free speech became part of the American fabric. You know, you could actually oppose the Constitution and not be demonized. John Jay, Alexander Hamilton, James Madison, they wrote the Federalist Papers and they were extolling the virtues and pushing the Constitution. But the opposition had vocal luminaries of its own. Patrick, give me liberty or give me death, Henry. Founder Sons of Liberty, Sam Adams, the proposal of the Virginia Declaration of Rights, George Mason, the man that proposed independence to the Second Continental Congress, Richard Henry Lee. They all opposed the Constitution. Free speech, that's when free speech was actually born, not only for America, but for the world. Something else happened during the course of the ratification process. There was that free and open debate wasn't the only thing that took place across the country. The degree to which the general population participated was unknown throughout human history. Typically, up to that point, you had to be a property owner to vote at all. And for the ratification process, the property ownership requirement for voting, for electing delegates to the state ratification conventions, was waived. That was the beginning of the process of inclusion that we are still going through today. There's another element to the process of inclusion we're going to talk about. But by the standards of history, such widespread participation in the organization of government had not taken place anywhere in the world previously. Now in 2016, there's 192 nations in the world. In 123 of them, the people participate in their government in a meaningful fashion. That was unknown. The changes, and I think it's really important, sometimes people throw around the term American exceptionalism. Those ideas are really, to me, what American exceptionalism means. Now, Constitutional Soundbites talks about the two keys there are to understanding these documents, both as they were understood in the 18th century, and at least I'm of the opinion if we don't understand them the way the folks wrote them, then in fact they are not law and we are lawless. So I think it's very, very important to have an understanding of what was meant when they were written. One of the first keys that is pointed out in the book is that language, in fact, changes over time. And the language of the 18th century is not the same as the language we speak today. Can you imagine if either Ben or George saw these little icons, saw Twitter and YouTube and RSS feeds and Instagram and things like that? They'd have no clue what's going on, what that means, what even those icons mean, let alone the fact that we communicate in 140 characters. And so we don't necessarily understand all the words as they understood them. There's a really great example that is also in the book. More perfect union comes from the preamble. We say more perfect union. What is perfect, more perfect? How can we be more perfect, right? We can't be, at least in the 21st century understanding of the term perfect. It's flawless without fault. But in the 18th century, perfect didn't mean flawless and without fault. It came from the Latin term perfecere, and that term meant to complete. And so when Gouverneur Morris wrote a more perfect union, what he was referring to was a union that was more complete than the union that existed under the Articles of Confederation. That's one example of the language differences that sometimes people utilize to twist and turn these things to their own purposes. The book also covers some other terms like, general welfare. What did general welfare mean in the 18th century? And what did commerce mean in the 18th century? They meant things different to the fellows that wrote them than what they've become to be our understanding. There's a second aspect that's unspoken, and this is, or untaught. And this actually goes back to the importance of the fact that there were so many lawyers involved in the drafting of these documents. There's a couple things I'll tell you about lawyers. One is that good lawyers, generally speaking, imitate and improvise. We have a form for everything. We have a form for real estate contracts. We have a form for deeds. We have a form for wills. And they had forms in the 18th century as well. And surprisingly enough, though the way we keep the forms on CDs or in the cloud or something like that is different than what happened in the 18th century, obviously, a lot of the forms are still the same. And the forms are kind of replete with legal meaning. The forms have changed a little over 200 years since lawyers continue to imitate and improvise. Now, a closer look at the Declaration of Independence and the Constitution reveals what Jefferson and Morris did. They imitated, improvised, and used their form books. As for the Declaration of Independence, it so resembles a legal complaint it very well might have been the United States versus King George. There were 5 men on the committee for the drafted declaration, but Jefferson largely did it alone. And if he didn't have a form book with him, he no doubt knew the form in his mind. The terms of a legal complaint, generally speaking, open up with a whereas statement. It explains the purpose of the document. Goes through a statement of law that applies to the matter, a statement that describes the conduct of the defendant, a statement that describes the conduct of the plaintiff, conclusion that applies the law to the conduct of the people, and a signature of the plaintiff. That's how it starts out. That's how a lawsuit starts. Declaration of Independence. When in the course of human events, while Jefferson knew that things started with a whereas statement, they were declaring revolution. They were trying to get rid of the king. And generally speaking, when you say whereas, it sounds sort of like a royal decree. So that's why Jefferson didn't start the Declaration of Independence with whereas, because he didn't want it to sound so much like a royal decree. But he talks about the self-evident truths. He goes through the inalienable rights, the purpose of the government, the indications of the need for the consent of the governed. He gives a statement of law. He's got his list of grievances against the king, which is the king's bad conduct. He talks about the conduct of the colonists as the humble petitioners. He paints his clients in a very nice light, which any good lawyer is going to do. He says nice things about them. Then he applies the law to the facts, and the fact is the only end result, independence. And he pulled that out of the form book. So this is what Jefferson did, but it's common to say when we talk about the Constitution, things about enumerated powers and limited government. It's found nowhere in the Constitution. From May 25th, 1787 until September the 8th, the delegates had worked together to come up with agreement on how they're going to proceed, how they're going to organize this government. They actually had put together 23 different articles, and they had all kinds of amendments and notes, and if it was today, there'd probably be sticky notes all over the papers, and they would have been sort of like this and shuffled together and not necessarily all that well kept. And on September the 8th, they appointed something called the Committee on Style that was going to take all these things together and turn them into the Constitution. And much like Jefferson, Gouverneur Morris took all that stuff and went to work largely alone. Gouverneur Morris is probably one of the most unknown founding fathers, and he wrote, ultimately, the Constitution. James Madison himself attributed the style and structure of the Constitution to the pen of Gouverneur Morris. So how did Morris do this? He did it in 4 days. They've been working 4.5 months. How did he do it in 4 days? Excuse me, he pulled out his form book. And the implications for the Constitution were immense. He took those 23 articles and plugged them into a form that not only organized the Constitution, but is chock full of meaning. It's clear that Morris pulled out his form book and turned to the page that said power of attorney. The effect on the meaning of the Constitution is just immense. Now, a document that most of us are familiar with these days is something called a healthcare power of attorney. There are, however, powers of attorney for many things that we don't use as much these days, but in the 18th century, powers of attorney were used for just about everything because people that ran a business, if they left town, they needed to appoint somebody to run their business for them while they were gone. And they didn't have the communication things to look after that. So everybody involved in the drafting of the Constitution understood what a power of attorney was. And what is a power of attorney? A power of attorney allows one person, called the agent, to act on behalf of another, called the principal. Principal grants the agent the authority to do specific things in specific situations about specific subjects. Authority might be as limited as signing a document at a real estate closing, or as broad as making healthcare decisions. A power of attorney creates this distinct relationship between the principal and an agent. It consists of those elements over here. Its structure has the parties being identified, purpose of the documents described, responsibility, powers, duties, and relationship to third parties of the agent are defined. Limits on the agent's authority are placed. Provisions for altering, revoking, and at some point perhaps successor agents are part of the document. Now, if you take the Constitution and you lay it side by side with the power of attorney, it's the same thing. Starts out defining the principal, we the people, right? Defines the agent, the United States. The United States is the agent. This is very, very important. And it describes the purpose of the agency, which is in the preamble, ultimately to secure the blessings of liberty. Authority granted to the agent, you're going to find in Article 1, Section 8, the enumerated powers, what we call the enumerated powers. There's certain other things in Article 2 about the President, Article 3 about the Supreme Court. There's limits on the agent's authority. Article 1, Section 9 is sort of called the mini Bill of Rights. You can't suspend habeas corpus, a few other things like that. Certainly the amendments 1 through 8 are additional limits on the agent's authority, those amendments in the Bill of Rights. Provisions for altering or revoking the agency, which is crucial to Kyle's work these days, Article 5. And Article 5 really does provide for not only altering, but perhaps revoking the agency. And this is kind of important because in the book it mentions that this actually derives from part of the Declaration of Independence that talks about the right of revolution. They tried to build the right of revolution into the Constitution to make it possible to have a revolution in a bloodless manner. We may be experiencing one these days. So this is, when you put those side by side, and what does this mean for the Constitution? Well, what it means is that when a power of attorney is created, the principle defines and limits the agent's authority. That's why nobody ever had to say enumerated powers in limited government, because it was in the form of the document and it was commonly understood. It's a common understanding that we don't share these days because we don't look at it necessarily in that fashion, and because a lot of people take all the words and convolute them and try and make things for their own particular policy purposes. But actually the document's not that complex. And the agent owes a principal a duty which we describe as fiduciary. The agent owes the principal the duty to be fair, to follow the instructions, to not go outside the instructions. The implications for the meaning of the Constitution in the structure are just incredibly immense. Now, I don't know how many of you have a healthcare power of attorney, but if you do, you've probably read it, and you sit and you have it where it says, I appoint so-and-so to do this, and if you have a DNR, a do not resuscitate, you expect them to follow that. Or if you have a particular treatment that you tell them you don't want, you expect them to follow that. We should expect no less from our agent, the United States of America. And I think that's kind of a secret of the Constitution that is seldom, frankly, I don't know of anybody else that's talked about it besides me. But it's very, very clear that there's I've seen readings. I know Professor Nadelson's been involved in some of the Article 5 things, but he's strong about the fiduciary duties of this of the government that are built into the Constitution. So when you take the 21st century power of attorney and lay it side by side with the Constitution, it's the same thing, and we should expect no less. So lofty ideals plugged into simple form, chock full of meaning, pulled out of a form book, because what do lawyers do? They imitate and improvise. They don't try and recreate the wheel. They just sort of try and plug things into something that they know. But there was a commonality of understanding that these fellas had that we should have. And that would go a long ways towards our expectations of our government. Final word about Gouverneur Morris. The phrase which every American has come to know is in fact the work of Gouverneur Morris. When he set about the work of collecting those 23 articles and other things, he got an original draft of preamble. The original draft of the preamble said, "We the people of the states of New Hampshire and Virginia and New York and another 10 do ordain and establish." Morris, in fact, is the one that changed that phrase to "We the people of the United States of America." And in doing so, the document creates a nation rather than an organization of governments. The meaning was immense. And the fact that people hardly know or know anything about Gouverneur Morris is just amazing to me, because he had such an impact on what we did here. Over the centuries, since the Declaration of Independence, there's been a lot of folks trying to dismiss the founders as a bunch of old white guys, a bunch of rich old white guys. Of course, they overlooked the fact that Jefferson was only 33 and Morris was only 35 when they wrote the Declaration and Constitution, respectively. I call their attention to a couple other guys, Thomas Lynch and Edward Rutledge. They signed the Declaration of Independence. And Jonathan Dayton, for whom Dayton, Ohio was named, he also signed the Constitution. Those three guys, if they were alive today, they'd be young enough at the signing to still be on their parents' health care under Obamacare. So they weren't all rich old white guys. And at any rate, the process we call today inclusion, beyond the waiver of the property rights, or beyond the waiver of property ownership to vote, something else happened. On the very first day that the Constitution was finished and sent out to the states for ratification, they had to send it all around the country for that purpose. But it was very simple in Pennsylvania, because the Pennsylvania State House was the same place what we know as Independence Hall. And all they had to do was walk the document upstairs. And when they walked it upstairs, the Pennsylvania legislature ordered 4,500 copies of the Constitution to be made, to be distributed around to the people of Pennsylvania. The interesting thing about that, though, is that they only ordered 3,000 of those copies in English. 1,500 of those copies were printed in German. Fully 1/3 of the people of Pennsylvania did not speak English in 1787. And the folks that not we, but many people call the rich old white guys that didn't care about anybody else, were the guys that in fact started the process of inclusion by seeing to it that people that did not speak English but were citizens of the United States of America, or the proposed United States of America at that time, had the information in the language that they understood best to be able to make a good decision when it came to the question of ratification. The similar thing, as a side, you probably know this, but before New York was New York, it was New Amsterdam. And a similar thing happened in New York, and when they went to distribute the Constitution, they not only distributed it in English, they also made wide distribution in Dutch to accommodate the Dutch speakers of New York that were left over from when it used to be New Amsterdam. There's another story about that, but we don't have time. But at the very start of this experiment of self-government, the process of inclusion was started. And I would say that it continues today, but people should understand that these guys are the guys that set these things in motion. Rather than judge them by what's going on today, should judge them by the standards of their time. And by the standards of their time, they were just immensely ahead of the curve in terms of starting to try and include people that were more than just their little group. And that story and the ideas behind that story kind of drove our work for Capsulas Informativas Constitutionales. There's 36 million Americans in this country that are more comfortable in Spanish than English. And we worked, Dr. Arias and I, the past president of the Illinois Latino Council on Higher Education, worked for over a year to try and take 18th century English and put it accurately into 21st century Spanish. Because it's one thing to translate something, but it's a whole nother thing to make sure that the meaning is the same. So we spent a year doing that, and we did that right. Following is a story from the epilogue. And around the turn of the last century, around 1900 or so, my grandmother was one of 11 children in Lithuania. Russian Empire was in flux, violence spreading across the empire. Lithuania was occupied. She made her way to the United States on a boat by herself at 15 years of age. She married and met another Lithuanian immigrant here in Chicago. They eventually founded a beer business. They became beer distributors, which explains how I delivered my first case of beer when I was 5. And how I was driving a beer truck before I drove a car. At any rate, 8 of my grandmother's brothers and sisters were killed by the Russian occupiers, by the communists. She was born in September. She demanded we celebrate her birthday on the 4th of July because that was the day she considered herself to have truly been born. It was the anniversary of her taking her citizenship oath. Now that's my family story, but the fact is that's the story of everybody here. There's somebody in your family, there's somewhere, somebody that went for freedom, whether it was 400 years ago to avoid religious prosecution, whether it was somebody that ran north on an underground railroad to get away from slavery, whether it was somebody escaping communist oppression. There's somebody in your family like my grandma. And on the 4th of July that's coming up, I think we not only need to celebrate the founders and their work that put things in motion, but also the millions of others that they inspired. And we'll look at a couple of answers. Let's see. Well, I'll tell you what, I'll put those on the side for a moment. We'll start the questions, and go ahead.
My question has to do with the Constitution as written is expressly difficult to amend. It's,
yes.
And for the reason that they didn't want it to be done lightly, and we know from constitutions around the world, they're immense. Ours is very, very short. So what is this concept of the living Constitution that we constantly hear about from the liberals? How did it arise, and why is it gaining so much power in the minds of many, many people, if not the majority of people?
Charles Evans Hughes. Justice Hughes started a thing where he did away with the considerations of the underpinnings of what Jefferson called the law of nature, and nature's God. And when you say the Constitution would make it up as long.
Baseball rule book for the major leagues, right?
Yes.
It is a constitution, and the umpires do not have the right to say that if you get to first base after the ball is thrown, you're safe. So there is a constitution is by nature a rule book.
Correct.
And if you want to change it, you have a process to change the rules. And all of this other stuff, to me, is propaganda, nonsense.
And that's exactly what Roberts said during his confirmation hearings. he said, my job is going to be just to call the balls and strikes. He used the same baseball analogy during the time that he was being confirmed. Obviously, Roberts has not followed his promise of what he said during his confirmation hearings. And you're right, it is difficult to amend, and we right now are going through the longest period in time where we have not passed an amendment, and that's because, generally speaking, people have come to accept that we don't necessarily need to amend. We can just go ahead and litigate. And that's a huge problem. And one of the reasons that that's the case, and one of the reasons that the court gets away with such a thing, is that people don't know this stuff. And I'm doing, again, what I can. We're going to try and, we're working on a charter school program. That's why I was so happy to see the South Carolina Act. Why did they get away with it? Because folks don't understand what's really simply, as Jefferson put it, common sense. It's not that complicated. Everybody, Justice Hughes made it much more complicated to give himself carte blanche to do whatever he wanted. And it starts with Charles Evan Hughes. Yes. Yes, sir.
I just want to pick up on what this gentleman said about the living constitution. Isn't it true? Whoops. Okay, whoops. Okay. Isn't it true that almost immediately after the Declaration of Independence and the Constitution was formulated, that the elites of the world or the critics of that started to tear it apart almost immediately and wanted to tear it down immediately, and it's evolved from that, and that's just a strategy to tear down the Constitution by thinking that it could be updated as we feel as we go, and we don't have to really worry about what the old men thought and so forth.
You're absolutely correct. That's something, that's a number of things. At the moment, I've got another book in the works. At the moment, that's why this book ends at the Bill of Rights, because there's a purity there that ends with the Bill of Rights. Once you get to the 11th, 12th, 13th Amendments, different kinds of things start to happen that have lost the purity. I will say that there was you would think that the people in the second or third Congress would understand the First Amendment and no abridgment of freedom of speech, but in fact they did pass the Alien and Sedition Acts in 1798. And fortunately, in those days, that's one of the reasons Jefferson got elected to be president, because really the people declared the Alien and Sedition Acts unconstitutional. The voters in those days understood the Constitution, and once the government overstepped their bounds, they threw out John Adams and his crew to Thomas Jefferson, who, by the way, when he was leaving office, his most favorite thing to say was he got rid of every internal tax that existed in the United States, and he says, as long as anybody will live, they'll never see a federal elector. Jefferson had the right idea, and he was part of but of course he had written the Declaration and understood those aspects of the founding. So you're right. No, it's been a constant battle, as Madison put it. Every word in the Constitution decides a question between power and liberty, and power is always trying to restrict liberty. So, and the best defense against that, education and understanding. Yes.
Hi, David. This is David Perenboom. One of the stories I read years ago, and maybe you know it, let's see, about the constitutional period there and the founding fathers, whatnot, was that George Mason, who was a Virginian,
yes,
and he was somewhat involved. Of course, he was involved in a lot of stuff. I mean, he might have been one of the signers. I don't know, but
he was in Virginia at the time.
Yeah, okay. But anyway, he criticized the Constitution on the basis, he said, if it had been up to me, he says, I would have started the Constitution with the Bill of Rights, what the government cannot do, and then I would structure it. So that's a story I read. I don't know if you comment
That's
on
entirely,
that.
that's entirely accurate. That's in fact why Patrick Henry did not participate in the Constitutional Convention, despite the fact that he was asked to, is because he said, "I smell a rat," about that. And George Mason was of the same ilk, and in fact opposed the Constitution originally. That's when Madison and his crowd promised that if the Constitution were adopted, in fact, they would add a Bill of Rights. And a good example for folks today, you would like to think, Madison and his people in the first Congress, even though they won a huge majority in the first Congress, went ahead and kept that promise. They were extraordinarily honorable about keeping the promise to add the Bill of Rights. Madison ultimately proposed 22 individual amendments. The Congress whittled them down to 12, and 10 were accepted, what we become known as the Bill of Rights. Of course, another one of them was ratified 202 years later in 1991. It became the 27th Amendment. It's our last amendment, but it was still pending from 1789, and it had to do with so 11 of the 12 eventually became ratified. But that's an interesting story too, about a college kid in Texas who wrote a paper on the unratified amendment that was still pending around, and he started writing letters to legislators around the country, and eventually in 1991 they came up to the three quarters of the states needed to add the amendment that had been proposed in 1789. And interesting thing, geez, I'm trying to think of the fellow's name. He still works in Texas, but he got a C on the paper, and he ultimately amended the Constitution of the United States. It was a university paper, but he did get a C on the paper. So, anything else? I'd be happy to try. Okay, I'm going to randomly. Oh, I'm sorry. Please.
Since you were a prosecutor, are you going to entertain a question about being a prosecutor? And
Certainly.
okay.
Certainly. I'll tell you what, there was only one job I had in my life that was better than being a prosecutor, and that was being a helper on a beer truck.
I think you should have stuck to the beer truck. Yeah.
Was I that bad?
Okay. Today, Dennis Hastert reported to prison up in Minnesota,
Yes.
and he's going to be serving a 15-month sentence unless it's truncated for one reason or another, probably because he's going to be dying. But he was sentenced based upon an offense for which he was not convicted. He was convicted on violating banking laws, but he was sentenced based upon sexual abuse. How can that happen?
Judge Durkin apparently considered the aspects of the alleged sexual abuse as part of the aggravation in the case related to the fact that Denny Hastert had lied to the FBI about certain aspects of this. So in that case, Judge Durkin considered that aggravation to be more recent than the actual sexual abuse in those days. Do I agree? Frankly, do I agree with the idea of prosecuting somebody for something because you can't get them on something else? I don't. I don't agree with that philosophically speaking. On the other hand, they got Al Capone for income tax evasion, you know. They never did get Al Capone for murder. So were we better off with Al Capone in prison? Perhaps. Is there any benefit for Denny Hastert being in prison at this juncture in time? I don't know. I don't know. I don't know the details nor the facts, but I would say that prosecuting somebody for something that you can get them, and frankly, my own personal opinion about this law that says you can't take out $10,000 of your own money without reporting it to the government, I think that's absurd. The underlying law that they prosecuted Hastert for, I think that's absurd. It's your money. Why does somebody have to tell the government that you did that? So that's a different question or a different answer than perhaps you're asking. But I do know that, of course, I do know that Judge Durkin took into consideration some of those, some of the more recent, or at least that's what he said in his sentencing message, was that he considered things of more recent ilk, indicating that despite Mr. Hastert's alleged remorse, he wasn't really remorseful because his conduct recently was not lawful or legal. On the other hand, I don't think it's terribly fair that the FBI can lie to you and you can't lie to them. So that's that's a problem for me too. So there's all kinds of problems, and one of the reasons, like I said, I end the book at the end of the 10th Amendment, is we haven't necessarily always been adherent to the principles, but I think we would be more adherent to the principles if people understood them.
Thank you for your candor and your wisdom.
Thank you. Okay, anything else? I'll try and, let's see what we got. Speech, religion, protest. No. Speech, religion, gatherings. Yeah, okay. Gathering, that's not exactly how it's put. Let's see. Religion, press, speech, assembly. That's only 4. Yeah, there's 5. This is really a good group because they know better. Almost all the time, I get an answer that says right to bear arms, because people know that one. Speech, religion, assembly. So far, everyone is something that's in there. Religion, press, assembly, petition, which is still only 4 out of 5. Freedom of speech, freedom of press, freedom of religion, freedom of assembly, freedom of petition. That would be 5 out of 5. This is the first one I have here that's 5 out of 5. It goes religion, press, speech, religion, speech, press, assembly, and petition the government for redress of grievances. Before I mention who the winner is, and before I give out this little award, why only 1 in 1,000 Americans get this is almost all of them almost nobody gets petition the government for redress of grievances. Okay, you know why? We lost it. We don't have it anymore. In the 1840s and 1850s, Congress was inundated with petitions to abolish slavery. Now, something that petition for redress of grievances, you would think that they wouldn't put that in there with religion and speech and press and assembly if it wasn't really, really important. Okay, and in colonial times and during the origins of the country, when you sent a petition to the legislature, you didn't send a letter, you didn't send an email, you didn't get a Pony Express. The legislature actually had an obligation to give an up or down vote on what it was that you petitioned about. They had an obligation to hold hearings in committees. In fact, that petition situation is what was responsible for the committee organization that we know now in our legislatures. They had committees to hear these petitions from citizens, and it wasn't just citizens. Slaves would petition, minors would petition, and it was very, very important. So you had not just the right to send them a letter, you had the right to have them actually entertain your ideas. And in the 1840s and 1850s, the folks that were in charge of the Congress, in those days it was the Democrats, they established something called the gag rule, and they refused to hear petitions that had to do with the abolition of slavery. And we now no longer have the right to petition for redress of grievances the way it was meant when it was put into the First Amendment, which is why nobody knows what it is. And it's a cautionary tale about the rest of our rights, because we have, in fact, lost one of the rights in the First Amendment. It's gone. It's gone. One of these days, I think I'm going to send a proposal to my congressman and ask him to hold hearings on it. And if he doesn't, maybe take him to court and say, you have an obligation to do this, and ask for a writ of mandamus. One of these days, hopefully I'll be not too busy to do that. Or hopefully maybe somebody will be inspired to do that, to recover our petition for redress of grievances. At any rate, the winner of getting all 5, and you know what? I've done this 8, 10 times. Nobody's ever gotten all 5, and I think there's more than one here, this is just a great group. At any rate, the one that I got first, Graham Jarvie. So anyway,
It's extra large.
it's just large, so Graham, you may have to find a gift, maybe make this a gift for somebody. We, back when I did a thing for Ave Maria University on Constitution Day, we handed these out for a large group of students, and they were pretty popular because, of course, they've got George Washington on the front. Okay. And it says Constitution Day, September 17th, 2015, okay, because I only got a few of these left. But the important part is on the back, religion, speech, press, assembly, petition for redress of grievances.
And I actually became a citizen in 2014.
God bless you, Graham. Congratulations. Thank you so much.
Thank you very much.
Graham, welcome.
Thank you. Appreciate it.
Thank you very much. And thank you, everybody online. Kyle?
All right, thanks a lot, Dave. So a few things before we close for tonight is, on your tables, you have a survey form about how we do. We would love to have your feedback for tonight's event. Your feedback goes a long way on how we can improve our event offerings at the Heartland Institute, so we definitely could use your feedback. Second is, if you have not, we encourage you to sign up for our emails, for our Heartland Weekly email updates, the leaflet about what goes on with legislation, and also for the digital versions of our newspapers. Some upcoming events that we have at the Heartland Institute is, first, please keep in mind that the benefit dinner, our 32nd annual benefit, will be on September 15th at the Cotillion in Palatine, Illinois, featuring P.J. O'Rourke. Please note that early bird rates are going on until July 31st, so if you're interested in going, we encourage you to go to heartland.org and get your ticket now, because tickets are going to be going quick for a popular speaker like P.J. O'Rourke. Our next event at the Andrew Breitbart Freedom Center is next Wednesday, featuring Julie Kelly on the issue of genetically modified organisms in foods. So we're going to have a real interesting discussion about GMOs and foods and that. So we would encourage you to come on back next Wednesday. Begins at the same time with the reception at 5:30 and the actual program at 6. And lastly is the next event for the Center for Constitutional Reform is going to be on July 27th, and we are more than honored to bring from Wisconsin Eric O'Keefe, the legendary patriot who spoke out about the injustices of the crooked John Doe 2 investigation in the state of Wisconsin, where a rogue district attorney in Milwaukee County, Wisconsin, went on a witch hunt against conservative issue advocacy organizations that were trying to promote the agenda of the Scott Walker administration independently from the governor's office. So we would love to have you come on July 27th for that event, as Eric O'Keefe is going to say from his own words what really happened these past 2 years before the Wisconsin State Supreme Court ultimately struck down the investigation last year. And other than that, thank you everybody for attending. Have a good night and drive home safely.